for one sunny latest update no high na nyini egu sirome ko bia e be ko so de abramo yen se brede yen kan de won chairman enro yin nyina hu the latest information by nana from na ekone ba obi e kan wasam na edefa jakpa case just beka amanfo brina de won se mene bonse ni petition CID bonse bonse no be first so unity CID for some bra case we mo na just go for dame ono so the case akopimo court and no cramp no and ho answer or respond e court just ni nyina na mframa ma ye hu de kubia na eno korea and it is one citizen just ebeka or the petition ako presidency say be one of the Supreme Court judge Justice Kulendi yenye de yenyin free ho yenyin free ho and oil constitution ma nyema 2 and a bit ma ye Supreme Court justice free ho 1 incompetence 2 misbehavior. So any amount of comma CID information batches and where be not the comma the presidency. Now see procedures faso a year the sa Justice Kulendi everyone and to say the same procedure faso a year uji procedure faso yedi a chief justice for a different procedure the first with the Supreme Court justice na we no yenya alliance we broma bem just some be chicheni many so say we could the president or president be transfer ma the chief justice na said the nyina nim no you say akwa the president or so latest update is Mahama be transfer ama chief justice ama just a process na chance akosi sen yen couldn't quit information in chichiri muda hoye.
Coming up next, there's been a lot happening in the past few days related to some specific individuals. The latest on the plate is that a petition is reportedly in the works to remove a Supreme Court justice. We have the name Yonny Kulendi. And what exactly is this? What is this all about? What's the backstory? How is this really playing out right now? And if this is to be considered, what process will that go through? What is the area of law that would apply if this matter is to be considered at all? But barely 24 hours after petitioning the Criminal Investigations Department of the Ghana Police Service to investigate Justice Yonny Kulendi and Richard Jakpa over the alleged interference of administration of justice, Daniel Mafo Oforiata, a Chebi indigene, has escalated the matter to the presidency. Now, this time, he is asking President John Dramani Mahama to remove Justice Yonny Kulendi as a Supreme Court judge. My colleague, Dennis Wadam Esquire, has been following this matter as it's been unfolding over the last few hours that we've been watching quite closely. And what exactly is this gentleman seeking, especially when it comes to the matter of the position of the law and if this is going to be considered, what this process will be. Yesterday, that is good to have you. Yesterday, we got to hear of Daniel Mafo Oforiata's name for the very first time because he petitioned the CID of the Ghana Police Service.
Exactly.
Now he's escalated the matter. And what is he asking for again?
Well, so that's what we are learning. That's beyond the petition that he put before the CID for some investigations to be conducted in respect of allegations he makes against His Lordship Justice Yonny Kulendi and Richard Jakpa in respect of that conversation which we specifically detailed last night, a fallout from that particular trial, the ambulance trial last year, in which Dr. Kesi was standing trial with 2 others. We are now understanding that he also put before the presidency another petition, this time around seeking the removal of His Lordship Justice Yonny Kulendi in respect of the same matter. We are only able to tell because what we gather is that from what was contained in the statement or the petition to the CID, it's basically on the same issues that have now been put in a petition again to the presidency. Mind you, this will come directly under Article 146, and we, as the law is, when it gets to that stage, matters are very confidential, supposed to be in camera, right from the petition to when the committee is done with its work. That's if it ever progresses to that level. But the only reason we are able to understand what went into that petition is because we have already dealt with a certain leg of this matter, which is before the CID. And the understanding we get is that this petition, which we understand has been submitted to the presidency, is also predicate on the same or substantially on the same set of facts, Alfred. So that's what we are learning.
I see, but then again, if this is to be considered, and we're very mindful of the boundaries of our conversation on this as well, because as you indicated, it's early days yet. What's the process going to be?
Well, so that's also opened up another conversation which has been a very controversial one, and that has to do with the removal of the Chief Justice. Now there's an argument whether if the Chief Justice is removed as a whether the Chief Justice removed as a Chief Justice also loses the position of a Justice of the Supreme Court. Those who think that should not be the case argue that the removal process for a Chief Justice is different from the removal process of a Justice of the Supreme Court. In this case, if it ever progresses, we'll be looking at the removal process for a Justice of, of the Supreme Court. And that takes us, again, to Article 146. Except this time around, we are looking at it from the point where this would trigger a process that will have to do with the removal of a Justice of the Supreme Court and not necessarily a Chief Justice.
Chief Justice. So, then this particular provision in this article strictly applies, so that then you wouldn't have to import any other ruling in the case of Ejechum and others. This strictly applies.
Yes.
Because it's not a Chief Justice.
Exactly.
It's a Superior Court judge.
Yes.
Okay, let's get
So that's why we needed to emphasize the point that the removal process for the two individuals is separate. So when you look at it, 1461 says that the Justice of the Superior Court, or in this case, let's just stick to what it is, because we know what it is.
Absolutely.
This is Justice of the Superior Court.
Perfect.
We're not dealing with chairman of regional tribunals. Shall not be removed from office except for stated misbehavior and incompetence, or on ground of inability to perform the functions of his office arising from infirmity of body and mind, that the Justice of the Superior Court of Adjudicator may only be removed in accordance with the prescribed, with the procedure specified in this article. Now, this is where it begins. This is the procedural aspect of it.
That's right.
That when the President receives a petition for the removal of a Justice of a Superior Court other than the Chief Justice, and for the removal of, he shall refer the petition to the Chief Justice.
Right.
When the President receives, he shall refer it to the Chief Justice, who shall determine whether there's a prima facie case.
So let's stay with that a bit. So in this particular the clause in this article, from what we saw in the case of the removed Chief Justice,
Yes.
a 5-member committee was set up. But this time around,
but let's see, we still haven't got there yet.
Let's go.
Yes, because remember, a prima facie was determined before the committee was set up. So we are still at a point where it says that when the President, upon receipt of that petition,
so which has been done now,
that's what we are learning.
Right.
But of course, receipts will also be acknowledged from the presidency.
Absolutely.
So we are hoping that if indeed it's been submitted as it's been reported, then the presidency would issue a statement to that effect, if they are minded to communicate the status of how things are shaping out. It's important to
say they are not obliged to let us know.
If it progresses, they would have to.
Yes, but
we have seen that in the case of the removed Chief Justice,
absolutely,
where we were informed that some petitions had been received and what the process was, and that was the beginning of the legal hurdles for that. But as we speak now, what we gather is that it has been. Except we have not heard from the presidency exactly what the status of it is.
Right.
But of course, for purposes of education, if it ever progresses, this is the procedure we are looking at.
Absolutely.
From the president to the Chief Justice, now we have an acting Chief Justice.
Yes.
So, and then there will also be a determination of a prima facie. This time around, this prima facie is determined by the Chief Justice. Mind you, in the other procedure that I've seen in respect of the Chief Justice, it was done together with the Council of State, the President of the Council of State. In this case, it's the Chief Justice who does that. Now, after that where the Chief Justice decides that it's a prima facie case, he shall set up a committee consisting. You see that this provision is very clear as to who does what. That he, the Chief Justice, shall set up a committee consisting of 3 justices of the Superior Court. There again, you see the distinction. In the case of the Chief Justice, Chief Justice,
yes,
there were 2 Superior Court justices. In this case, there are 3 of the Superior Court justices. They are appointed by the council, the Judicial Council, and 2 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State.
Right.
So clearly, there's another distinction here. In the case of the Chief Justice, you have 2 justices of the Superior Court. In fact, in that particular one, is 2 justices of the Supreme Court. This talks about 3 justices of the Superior Courts. So it could include justices from the High Court, Court of Appeal, and the Superior Court itself. So now that takes us back to those who argued that the processes were different. What they were essentially arguing is that if Justice Gertrude Tukono were to be removed as a justice of the Supreme Court, she ought to have gone through this process, and not one that had 2 justices of the Supreme Court, and
separate,
for which the Attorney General is seeking an interpretation. Absolutely. That's a matter which is still pending. But just like I said, for purposes of education. Now, upon the composition of this particular committee, the committee appointed under Clause 4 of the article shall investigate the complaint and shall make its recommendations to the Chief Justice, who shall forward it to the President. There again, you see a distinction that when the committee that was looking into the matter of the Chief Justice were done, they forwarded their recommendations straight to the President. They went and met the President, handed over that envelope. In this case, they are saying that the Chief Justice will make the recommendations. No. Let's stay here. Yes. Investigate the complaint and shall make its recommendations to the Chief Justice. So the committee goes to the Chief Justice, who then forwards it to the President. Then it continues. So where the petition is for the removal of the... No, this is for the Chief Justice.
Application,
yes. So the committee appointed under Clause 6, this is also in respect of the Chief Justice. But essentially, what it also ends in is the fact that whatever recommendations are contained in that the findings of the committee will be those that the President will be bound by. So the President shall, in each case it refers to, be it in respect of the Justice of the Superior Court or the Chief Justice, act in accordance with the recommendations of the committee. So this is how it generally looks like. Should this ever progress to the next stage. But like we said, this is what we are gathering based on the complaint that was made to the CID. We do know what the complaint generally is. And now we are learning that that complaint again has been put in the petition, which has been sent to the presidency, seeking the removal of His Lordship, Justice Yonny Kulendi.
And this person we're talking about is Daniel Mafo Foriata.
Yes,
and Daniel from Chebi. That's
Daniel
the man.
Mafo, yes, Foriata.
We have his picture. That's the man in black next to Richard Jakma.
Precisely.
Right. I see. And it's early days yet on this. It's one that we're looking at and following quite closely, as we did indicate. If the presidency is minded, as we saw in the case of the process as was started, where the former Chief Justice Gertrude Tukono, Phyllis Kwachofosu issued a press statement telling us about the receipt of the petitions. This time around, we haven't heard or seen any press statement whatsoever acknowledging receipt of this petition that is said to have been sent by this Daniel Mafo Oforiata, but it's one that we're picking up and following quite closely, the signals of this petition at the presidency and what's going to be happening in the coming days. So stay with us here on Ghana Tonight. But there's one other issue as well that we're learning this evening, which we've also been following quite closely, and that's coming up next. It has also to do with another individual on that list that we just showed you. The General Legal Council has begun hearing a misconduct complaint against former Attorney General Godfrey Yeboah-Dame over the ambulance trial. We've got the latest on this. then this process has started today. What do we know, Dennis?
So, as part of the many legs of this, I think this is one of the matters you can describe as looking like an octopus because it's almost everywhere. We did indicate that as part of the fallout from this ambulance trial, quite a number of things beyond the complaints to the CID, the petition to the presidency, there was also another complaint that was made to the General Legal Counsel in respect of the former Attorney General, the Leonard Godfred Yabo Adami. The complaint was to the effect that the way he went about the matter smacks of some misconduct, professional misconduct, for which this complainant wanted the General Legal Counsel to look at. That was somewhere in May. And we are now learning that the processes have kick-started. Now, mind you, the in-camera principle that applies to Article 146 proceedings also applies in respect of proceedings before the General Legal Counsel when it has to do with professional misconduct. So that also means that we are unable to get the detailed information by way of what exactly has been said, but we've been able to glean some information as to what stage of the process it is now and what essentially has been going on. So what we do know is that the former Attorney General has now given an answer to the complaint. So I usually, when the complaint is made to the General Legal Counsel, upon receipt of that, then they will make the complaint available to the respondent or the affected person to also answer to what the complaint, the issues that are raised by the complainants. So that has been done. So the former Attorney General has now given a response. In other words, he has responded to the complaint.
Okay.
That we understand or we gather that in doing so, he responded in about 6 parts. I mean, how he went about his presentation to respond in 6 parts. The first part, raising preliminary objections as to the way the complaint itself has been carried. Mind you, I had mentioned that it is supposed to be an in-camera proceeding. What it means by the same principle is that the complaint itself should not be published. But he observed that on the 22nd day of May, when this complaint was made, it was widely publicized, radio, TV, in newspapers. He thinks that it breaches the principle of the in-camera proceedings. So, to that extent, he raises the objection that it should be dismissed because already it has breached the rules of the procedure.
So it's in the public domain.
Exactly.
Okay.
Then again, he raises an issue about the capacity of the complainant himself, who claims to come under a certain provision of the Constitution. It is the view of the Attorney General, the former Attorney General, that to come under that provision without a personal injury does not clothe him with that capacity to come before the committee. So, in that respect, he wants that the committee dismisses the petition.
Resetting, no, I just say GM Council or be resetting Ghana, no. Tim say actions I would not take down or resetting baby or resetting baby. The judiciary in actions will take. Nyama Emma Ghana and Kulendi no or upgrade no or resetting the ashen for because it be more time. How can a country go forward if say the judicial system a weak? If say that our justice system a weak, country need to baby. So as a wise and visionary president no Oguso sakraya hodo or the judicial system no actions, bold action our take and found all the comments, all the attacks, all the demonstrations, all the picketing amount for a petition the international communities and found no or say yes or a bold leader. And that's how a leader should be. A leader should be fearless. And you see JM air coming into no Australia. If the thing is right, obeying is very big. No matter how a big critics, it's not the right thing obey. Ne you want actions in your casa. Right now, no petitions are by just say the gone. The in a furor, they remove chief justice or set a record justice Arabatukono yinefiro said the a buy now one tonight now uyinefiro and ne for so aba we Supreme Court justice just say one of our own Ghanaian ordinary Ghanaian a petition the presidency say nneema baako mienu binti Justice Kulendi on fata say or what the Supreme Court or yen in through non cotinefi on fata a position on fata ultimate my justice ember obe stating it clear na said the engineer formation by say the petition I could do presidency. Jay said the president and Alpha OneTV said they will stating it clear in a Mami Tokono case and Saka this petition ABC state say into or more or the Council of State as a prima facie no more developing with the onyam by bits formation by Chester and Saka. I can't say president Alpha OneTV confirm me sampa abedino. Nenya onyam confirm me no. We share the constitution in my union actually we are na pay the constitution with the president in Saka the procedure differs with a justice if the Supreme Court or no a different procedure first with the a chief justice or much but going by the constitution and I might breaking it down my answers. So, per the constitution, which I say, with the president in Saka, on fan command council of state, on fan command with the president in Saka, or the Beko command the chief justice. Said about chief justice, the command council of state, with the Supreme Court judge, they with the command chief justice. Now, chief justice, no, are for me prima facie. Now, you see, I should process in every prima facie in Yama pet na for the article committee no masha sian bobo one evidence when for branding in our casa no bobo one after the summit information about the president and the president na decide say I was so call and answer was so tina. So we latest update in Chichi Mind Abba. So this and many more not just APP go for that media and also no petitions are just say the amount in future money chess or no so no no so chess yembo cases in because already no running bo nipana or the petition by no matter to tom rather because there are some things in camera meanwhile some of the information that can buy one thing other. So when he has said or more to us our case and some dismiss the case. So these are the things that echo so subscribe. Menko like and share my own so the nyebinti. No so the latest information and Eboba higher for 1G Akroma.